Assalamualaikum warahmatullahi wabarakatuh. This is part 3 of the lecture Defamation. So, in the first two parts, we cover the introduction, classification, and the previous part, second part, we cover about the first element, which is the words must be defamatory, and it could be defamatory in three ways. It's either ordinary meaning, okay, or innuendo, or juxtaposition. So now the second element of defamation is the words must refer to the plaintiff. So meaning that here whatever defamatory words uttered or said, okay, or written, okay, by the defendant, so those words actually refer to the plaintiff specifically. Okay, we have the case here, E. Halton and Company and Jones, very classic case. This is common law, 1910. A fiction, okay, certain book, a fiction, okay, fiction book was written concerning an Artemis Jones in Peckham. So that's basically the description, okay, the character in the fiction. And there was in fact a real Artemis Jones, who is the plaintiff, okay? And he happened to be a lawyer in that town. And then the friends of Artemis Jones thought that the story concerned him, the plaintiff. And then that's why he sued the, the publisher, okay, of the fiction. So the court held that the defamation was established because why? Those who knew him, those who knew Artemis Jones, the lawyer, okay, understood the words was referring to him. The words were referring to him. Although actually that was not intended to be so by the author and the publisher, because when they wrote the fiction, actually they thought it is just imaginary, okay, fictional or hypothetical character. But it happened to be there's one specific person by the name of Artemis Jones within that area. So it amounted to defamation. So the second element is fulfilled. Okay, the word referred to the plaintiff. And then another case, Newstead and London Express Newspaper Limited. So dependent newspaper stated, okay, published that Harold Newstead, 30-year-old Camberwell man, was punished for bigamy. And actually, there were two people by exactly the same name with that age and within the same area. So, and then plaintiff was Harold Cecil Newstead, the same name, okay, and in 30s as well, and he was a hairdresser. And those who know the hairdresser here thought it was him. Okay, actually it refers to another Harold Newstead. And then when the case was brought to the court, one of the arguments is that okay, there's no intention, okay, to defame plaintiff here. But the court said absence of intention will not affect liability. Still, okay, liability can be proved. So the defendant, the newspaper, was held to be liable for defamation. And for local case, we have the case of Umi Hafilda and Kalangkraf, Samurhat. Plaintiffs, a witness in Anwar Ibrahim criminal proceeding, alleged that defendant published an article in Bacharia that the first plaintiff, we have two plaintiffs here, Umi Hafilda and Khairuddin, okay? That the first plaintiff, Umi Hafilda, was married to one Khairuddin. And who was Khairuddin here? Nephew of Sulaiman Palestine, a former UMNO leader. So Khairuddin, second plaintiff, he contended that he was the person named Darin. Okay, when the article was published in Macharia, actually it refers to him, even though it is stated as one Khairuddin. And then the fact is that both Umi Hafilda and Khairuddin, both plaintiff, denied they were married. They were not married, whereas in the article it was stated that they were married. So because of that, they allege that their reputation as business person, they both of them were having some business, okay, has been brought into disrepute and contempt. So it affects their reputation. And defendant argued that mere mention of Khairuddin, this is the defense, okay, by defendant, could not amount to a pointed reference to second plaintiff, Khairuddin Abu Hassan. Mean that, yeah, we don't really mean to that specific Khairuddin. But the court held that the article would lead reasonable people, the readers, okay, who know second plaintiff to the conclusion that the article referred to him. So there was liability for defamation. Meaning that here, when people read, oh, we know it referred to this Khairuddin, not others Khairuddin. Okay, before we move to the next point of discussion, okay, we want to discuss relevant here, okay, the defense of unintentional defamation or offer of amends, okay, because here, right, there was issue of no, sorry. Like in this case, okay, okay, in both of the cases, I think there's as if there's no intention here. Okay, whether the court will actually affect those defense, okay, unintentional defamation, or even what if the newspaper, okay, the publisher offer apology or amends, okay, want to make correction. It is covered by Section 7 Defamation Act. Okay, let's cross refer. Okay, Section 7. Okay, here, okay, it talk about unintentional defamation. It's quite long. Okay, you can read on your own later, but we're going to discuss the gist of it. Okay, all right, it has okay, 6 subsection. Okay, under section 7 here. Okay, it revolves around unintentional defamation. We go back to the slide. Okay. So basically Section 7, the long section just now, it provides a procedure, okay, where the defendant may avoid liability to pay damages for unintentional defamation. Meaning you no need to pay compensation, okay, for whatever defamation which was committed unintentionally. But what he has to do, defendant must publish a reasonable correction, okay, do correction whatsoever, and apology, and pay the plaintiff costs and expenses incurred as a consequences of the publication. And this is only applicable to works published innocently. If it is published with malicious intention, then you cannot apply this section 7. And then as far as apology is concerned, okay, apology actually is not a full defense. Okay, it is a mitigation, but it's not a full defense. So still, defendant might be liable to pay certain amount of compensation. We are going to discuss defense in the towards the ending part of our discussion. Okay, and this is the cases for defenses. We are going to discuss the case now. Okay, Tan Sri Datuk Winston Tan and Nurmala Shamsuddin and keluarga. This is appeal case. That's why we have 2 layers of cases here. Okay? Nurmala Shamsuddin, keluarga, and then keluarga communication and Nurmala Shamsuddin in 2006. So we are going to discuss the case of Nurmala Shamsuddin and keluarga communication. I think some people know her. I mean, quite a number of years back, she was quite famous. Okay, a new host or newscaster. Alright, so defendant had caused to be published 4 issues of Mingguan Wanita. So Keluarga Communication is the publisher of Mingguan Wanita. I think Mingguan Wanita is still available nowadays. Okay? Concerning the plaintiff, and plaintiff was actually broadcast journalist. And defendant reporter had interviewed the plaintiff via telephone, through telephone interview. And based on this interview, defendant published an article in the first magazine. And the defendant then published a second magazine which carried the plaintiff photograph, and on the front cover the words, okay, defamatory actually, okay, malah tebus talak 3 juta. Tebus talak is when you ask for a divorce, and then the ex-husband asking payment in order before she can be divorced. And within the magazine, under the heading heart age of the person Nurmala, her heart says yes, her lips say no. So it's defamatory actually towards Nurmala. And this is an article which inter alia mentioned a third person in her married life, okay, and the payment of 3 million to her husband to release her from her marriage bond. In the year he married the new husband, okay, but then for the previous marriage, in order to be released from the bond to get the divorce, okay, he has to pay this amount, which is actually affects her reputation. So because the interview was carried out through telephone call, okay, when he read the actual article, okay, upon reading the article in the second magazine, the plaintiff contacted the defendant and asked him to put right the incorrect matters published about her and to apologize for the same. No, this is not correct, and please do correction, and then please apologize, okay. So defendant published the third magazine, okay, which purported to comply with the plaintiff request, but still the plaintiff was not satisfied, okay, that the article in the third magazine had put matters right. Defendant then published the fourth magazine, which purported to explain the truth and to apologize. So there are 4 magazines altogether. And the court found that the apology that appeared in the magazine met the criteria of a full and frank withdrawal of the charges or suggestion conveyed, if any, regarding the plaintiff. And then further, okay, the apology should be regarded as adequate, noting that there was expression of regret, okay, by the defendant that such charges or suggestion were ever published. So it has to be a complete apology with no conditions attached, okay, a sincere one. Okay, for the case of Vincent Tan Chi Yon, Tan Sri Dato' Haji, Tan Sri Dato' and Haji Hassan bin Hamzah. So Haji Hassan bin Hamzah is because we have actually a number of defendants involved here, and 7 defendant was the printer, okay, and then there were actually 3 defamatory articles against the plaintiff, and the printer, they tried to argue under the defense of innocent publication. Okay, the emphasis is on the word innocent. But the court held that the defense failed because why? The plaintiff articles plainly referred to the plaintiff whose colored photograph appeared in the article. So it's very obvious. Okay? It's not really innocent. When you do the printing, you can see the picture. Somewhat is colored. So it specifically referred to plaintiff. So the defense of innocent publication was not accepted. Okay, another relevant issue to be discussed here is because we have been discussing the second element, okay, which is words must refer to the plaintiff specifically. What if defamation is aimed towards a class of people? Is it possible to defame a group of people together or the whole class, for example? Okay, is it possible? So the rule is that defendant will not be liable unless there is a direct reference to the plaintiff or certain individuals in a particular class or group. Even if it's a class, it has to be specific, limited number of people, specific, certain. We have 2 cases here, one common law and one local. Nuffer and London Express newspaper limited 1944. So this defendant's newspaper reported on the unethical activities of the Young Russian Party in France and USA. And plaintiff actually is a member of this Young Russian Party. And then he sued this London Express newspaper for such a report because it affects his reputation. But plaintiff action failed because why? The total membership of the party was several thousand. It's not 1, 2, 3 or 1,000, several thousand of members. So the report actually affected all the whole class. Okay, if any person were to be defamed, so it affects the whole all members, okay, of the party. And then for the case of Tengku Jaafar bin Tengku Ahmad and Karpal Singh, so Karpal Singh made some defamatory remarks, okay, towards Raja, okay, Raja Melayu, Raja. And then Tengku Jaafar actually sued Karpal Singh for that. And then the court said reference to Raja does not mean reference to the Malay race generally. So if the whole Malay in Malaysia, okay, wants to sue Karpal Singh, cannot. Okay, because why? This is defamation of a class. So it has to be very specific. Okay, but I think if let's say Raja Melayu decides to sue Karpal Singh, then it's possible because only specific number of Raja Melayu. But Melayu, okay, the word Malay is generally, so this is something which is unlimited number. I mean, big number, huge number. Okay, we are done with the second element. So we stop here. We are going to continue in the next part, okay, for the third element. Okay, that's all. Let me stop sharing. Okay, all right, that's all. Assalamualaikum warahmatullahi wabarakatuh.